Hello everyone, welcome back to the Black Letter Law Academy. Today we are going to understand Article 14 of the Indian Constitution. If you watch this completely, you will get the full concept intake, and I can guarantee you one thing, you will never forget it, and there is absolutely no need to memorize. So first, what does Article 14 really say? Article 14 says that the state shall not deny equality before law or equal protection of law. At first it sounds like one idea, but actually Article 14 contains two different concepts. Let me ask you first, why did the Constitution uses two phrases instead of one phrase, like equality before the law and equal protection of law? Because both the idea work together, not separately. Does Article 14 applies only to Indian citizen? No. Article 14 applies to any person. So see, any person. That means citizen, foreigners, companies, corporations, and even a legal person. Equality here is universal, not limited. Let us understand first equality before law. Equality before law is a negative concept. Negative concept means the state must not give special privileges to anyone. That is, no special privileges for any individual. In simple, no one is above the law. Status, position, wealth, none of this matter. A minister and the common man are equal in the eye of law. Okay. Then, see here, rule of law. This idea comes from A.V. Dicey, who called it the rule of law. Rule of law basically answers one question: who controls the country? People or law? Law. Law only controls the country. Daisy explained this through three ideas. These three ideas. Okay. First, supremacy of law. Meaning is government cannot act by vice. See, every action must have legal authority. So no one is above the law. Second one is equality before law. So no special court, no special immunity, no special treatment, regardless of rank or status, all are subject to the same law. So this is what equality before the law. So the third one is predominance of legal spirit. This part applies to England, not India, because India has a written constitution. So sources of right of individual is from Constitution of India. So remember, rule of law supports equality before law, but not blindly copied in India. Then equal protection of laws. Let me ask you a very important question. Does equality mean treating everyone exactly equal? No. Big no. If a rich person and a poor person are treated exactly the same, that itself becomes injustice. So equal protection means, so see, like should be treated alike and not the unlike should be treated alike. People who are differently placed or treated differently. So equality is about fairness. Okay, classification is allowed. Okay, Article 14 permits classification, but with the limited classification. Okay, now understand this clearly. Article 14 does not prohibit classification. Article 14 prohibit arbitrary classification. So classification must not be arbitrary, artificial, evasive. So the Constitution allows the state to classify the people, but only with the it is reasonable. So reasonable classification. Article 14 prohibits class legislation. What is meant by class legislation? So class legislation is when the law says, I like this group, I will favor them. I don't like that group. I don't like that group. I will ignore them. So this is what the class classification is. For example, a law allows only one caste to enter a public park. So there is no logic. There is no logic, no purpose, only discrimination. This is class legislation, and Article 14 strictly prohibits. So then what is reasonable classification? So reasonable classification is different. For the classification to be valid, both the test must pass. So first, intelligible differentia. So there must be a clear and understandable difference. Okay. So for example, income based classification is valid. Eye color based classification is nonsense. The second one is rational nexus. What is meant by rational nexus? That difference which you classified, the difference must be logically connected to the law objective. So it have to satisfy the objective of law or policy which you created. If either test fails, the law becomes unconstitutional under Article 14. Okay. So for examples, so we are providing the scholarship for economically weaker student. Why is this valid? Because the classification is based on the economic condition and the objective is educational. So this is reasonable, okay, not discriminatory. So this is valid. So why the equality is not absolute? So we have exceptions to the equality, okay. Equality before law sounds absolute. So but the constitution itself gives exceptions. So why? Because governance needs protection for certain officers. So that's why we have exception in Article 361. So president or governor not answerable to the court for official acts. So president and governor gets protection. So no criminal proceeding during their term of office and no arrest or imprisonment during their term of office. So civil proceeding only after 2 months notice. And Article 105, legislator get the freedom of speech inside the house. Diplomats gets the immunity. Certain directive principles are protected. So diplomatic immunity under international law. So these are the exceptions for the equality before law. So in this case, DS Nakara versus Union of India, this was the fact. So the classification of the pensioner based solely on the date of retirement. So it is arbitrary. So such a date based discrimination has no rational nexus with the object of a pension. So see, are pensioners really different from each other? No, all pensioners form the one class. Date based division had no rational connection with pension. So classification failed Article 14. So today we saw Article 14. So understand this clearly. Article 14 is not about blind equality. It is about non-arbitrariness, fairness and reason. If you understand this logic, you never need to memorize Article 14 again. So thank you. For more lecture videos, subscribe to the Black Literature Law Academy. Happy learning. Thank you.